Good morning, everyone. Thank you, and please be seated. We are here today for the submission of 3 cases. The first one is, excuse me, in the Marriage of Kraus, and it looks like the parties are ready. Ms. Fueger, am I pronouncing it correct? Thank you.
Good morning, and may it please the court, counsel. My name is Stephanie Fueger, and I represent the applicant Molly Kraus in this matter. This case presents an opportunity for this court to appropriately arm the district courts of this state with the necessary tool of dismissal in their arsenal to combat Rule 1.413 violations. When district courts are forced to devote their limited time and resources to processing baseless filings like the petition for modification at issue in this case, the goals of Rule 1.413 are compromised. As former Justice Cady noted in his 1987 Law Review article on the topic of curbing litigation abuse and misuse, courts are mandated to detect and punish offenders who violate Rule 1.413. By granting the relief requested today, this court assures the district courts have the available tools to carry out that mandate. In this case, the parties were married in 2000.
See, that was gained here, because it looked like the sanction hearing, to me, probably didn't look much different than what the modification trial would have been.
In this particular case, we had not even gotten to the point of having a trial scheduling conference. This case arose out of Delaware County, and there are certain court service days in that county, and so we hadn't even gotten to the point of scheduling trial. And so in terms of disposing of this litigation sooner than we otherwise would have, waiting for a trial scheduling conference, scheduling the trial date, that was the efficiency gain here.
Well, essentially had a mini trial on modification. That's what it looked like anyway.
We did have an evidentiary hearing. It was, I believe, a 1-hour hearing, which I think is less than what we would have had to have.
Just to resolve the case on the merits after this hearing and then impose a financial penalty. You'd still get the sanction, and then the party would have a chance to come to court and try to make their case. And I don't know, it didn't strike me as incredibly frivolous.
Well, in this case, I think if you look at all of the facts here, including the text messages that were sent by Mr. Kraus to my client within weeks of the decree being entered, evidencing a plan and a scheme on his part to try to undo the decree that he had just agreed to and which had been approved by the district court, that is where the substantial evidence found by the district court arose that there was a frivolous filing.
Common that people end up doing dissolution decrees and kind of have it in their mind that there's going to be a modification.
I don't think it's a super uncommon feeling to have some buyer's remorse after the entry of a decree. What I do think is significant about this case is to then act on it and file a petition for modification not grounded in facts.
And I sense your frustration, and I agree. I'm a former family law lawyer. I'm a former trial court judge. One of my biggest concerns and actually complaints was people quickly agreeing, stipulated decree, and then getting a modification on file at the turn of a head. I do think it's actually quite common. I liked where Justice McDonald was going. I'd like to hear you talk more about that. Why not file a quick motion to dismiss, have put on your evidence, or just have a quick hearing on that? The reason I ask that is I think it's easier to persuade a judge to grant a motion to dismiss than to give sanctions, and you could accomplish the same thing.
Certainly there were other avenues available, but I think in this situation where Mr. Kraus confirmed his intent, improper purpose here in filing the petition for modification during his deposition, where he had admitted that there wasn't a substantial or material change, that it was always his goal to try to change the decree.
For a motion to dismiss for you to fight against, isn't it? Great evidence?
It could have been an alternative, but I believe that Rule 1.413 exists for this very purpose, to discourage frivolous filings, and this was just that example.
Didn't our court already decide under the predecessor rule that dismissal was not an option?
decision in 1990, yes, there is one sentence in that decision that says that Rule 1.413 does not provide an independent basis. But there's no explanation in that decision, and so we come before you today asking you to change that decision and to find that in the appropriate case and in the appropriate circumstances that dismissal would be appropriate.
Particular case dismissal worthy, and I'm thinking about the idea that even if dismissal is among the options available to the district court, that we always look for sort of the least least powerful sanction, for lack of a better term, and it really does feel like to me that a monetary sanction or something else along those lines could have been just as good, perhaps.
Monetary sanction was awarded in this case, the attorney's fees, but also if this case is reinstated and it goes back to the district court, then we have a Rule 1.413 violation. The court has determined that the rule was violated in the filing. The appellate court affirmed that it was an abuse of discretion for the district court to find that, and we have a baseless filing pending until a trial date is set. And my client is then in the position of generating sufficient evidence to demonstrate that at the trial court level. I would assume even this case would be a one-day trial based on my experience trying lots of cases.
Trial dates are too far down the road to be successful for that, but that's what you do a hearing for. I mean, a motion to dismiss, that wouldn't have to take a full day, would it?
And in this case, I think a motion to dismiss time-wise or a motion for sanctions, practically speaking, would have been scheduled at the same time. But I think the sanctionable conduct here and the primary purpose of Rule 1.413 being deterrence to dismiss this action that was inappropriately filed serves that deterrent purpose.
Message to a lawyer who I may have from the bench found to have been filing something frivolous. I sent the same message, that deterrent, by saying, case dismissed, you are probably owed some attorney's fees, and guess what? Your client's going to pay the other attorney too. And that definitely is a deterrent, don't you think?
I do. But I also think under this rule, I don't believe that based on the fact, some of the reasoning that is set forth in the appellate court's decision, that handcuffing the district courts from not ever being able to dismiss a frivolously filed lawsuit serves the primary purpose. And so I'm not standing before you today saying that dismissal should be the go-to sanction or that it's the most appropriate sanction. I think it's a unique and rare, and I do agree it's a drastic sanction, but I think certain facts and circumstances warrant it, and I think this case is one of those facts.
Counter policy argument that allowing this, it leads to sort of satellite litigation that Mark Cady warned about in his law review article, or Judge Cady at the time. And then, so if we reverse and say, yes, sanctions on the table, well, you're now going to go back and have another hearing on that. And it just sort of prolongs the litigation for both sides. How do you respond to that?
This court were to reverse the Court of Appeals and affirm the district court decision to dismiss this lawsuit, I don't think that there would need to be another hearing. But with respect to satellite litigation, yes, we did have to have an evidentiary hearing on the motion for sanctions. But we conducted discovery in the underlying case. I took the deposition of Mr. Kraus, which is where he made the admissions as to his improper purpose. And so those discovery activities that were conducted were things that would have been conducted as part of the underlying litigation had the action not been dismissed anyway.
If we say hypothetically we don't agree that 1.413 provides dismissal as a sanction, could we affirm the order of dismissal on the of the district court on the alternative ground that it was within the district court's inherent authority to dismiss the litigation?
I believe so. And one of the cases that I cited in our application, the Luce v. Cooper case, it's an old case, but this court recognized the inherent authority of the district court to dismiss actions in front of it. And I believe as a court of appeals, this court is able to affirm the district court on any number of explanations that would otherwise support.
effect. I think Justice McDonald was alluding to this. There was kind of a merits hearing anyway, that Matthew had an opportunity to present the evidence that would have supported the modification, and the trial court thought that it was frivolous in effect. Is that fair?
Matter, how do we square your argument about 1.413, which doesn't discuss dismissal as a remedy, with other rules, discovery rules that do?
Yeah, I appreciate that question. So I would say in response, Rule 1.413 only speaks to costs and expenses of litigation or attorney's fees. But we know from the body of case law interpreting Rule 1.413 that there are a number of other sanctions that this court has affirmed being used, public admonishments. I think there was just a recent appellate court case giving an attorney the option of doing continuing legal education for a violation of Rule 1.413. So we know that there are available sanctions that are not necessarily enumerated. I would point out the Luce v. Cooper case that I just mentioned that definitively holds that the district courts have inherent authority to dismiss litigation, and this Rule 1.413, having been enacted after that decision, could suggest that the legislature recognized the inherent ability of the district court to dismiss actions and didn't need to specify the language of dismissal in this particular rule.
Concern that I have with your position, which is we know, I think 37% roughly of family law cases have one pro se litigant. I think 70% or so have two. That having this available as an additional tool may curtail some access to justice. It raises access to justice concerns for me in the sense that we know from experience that a lot of family law cases, maybe for better or for worse, are pretty thin, especially on modification issues. But that doesn't mean that a party necessarily has a bad faith basis. So, for example, if this father even perceived that the visitation arrangement that was in place wasn't working for his kids in the way that he hoped, I think that would be a good reason to come to court and seek a modification of visitation at least. So my concern is that we'll be using 1.413 as a way to kind of kick out pro se litigation and family law. So can you address that?
One of the things that I think is important to note is that in a petition for modification filed after a custody decree or a divorce decree based on somebody seeking to change custody, it isn't like a personal injury lawsuit, for example, that has a 2-year statute of limitations and there's one shot to file it. The petition for modification can be filed at any time that there exists significant or material based on whatever's trying to be changed. And so if this was available as a tool and if it were used, it isn't like those litigants are foreclosed indefinitely or forever from potentially generating the right type of evidence to bring forward in a subsequent modification action. And so I don't see that that is a concern to bar, for example, forever those claims. And I don't think there's an access to justice problem there. And I want to contrast this.
Evidence in this record from the father that he perceived, maybe fairly quickly, that this visitation arrangement wasn't good for his children and that he needed to spend more time with them. And that seems to me that would be enough to at least ask the court to modify the visitation schedule. Why wouldn't that be enough?
The appellate court was absolutely correct in characterizing that evidence as a red herring. The district court, who was in the best position because the district court heard the testimony of both parties and received the evidence and was able to make credibility determinations, found that those vague statements that the father was saying were not actually credible. And so there was no factual basis, and that it was in his mind at the time an opportunity for him to undo what he had just agreed to, not to try to change something that he believed was not working for his children subsequent to entry of the decree.
Look to federal authorities for guidance on what the appropriate remedies should be.
interpreting Rule 11 are persuasive to this court. I note that the court's decision in November of 2024, DePaco versus Iowa Iowa District Court for Lynn County, notes in a footnote that Iowa does diverge from the federal rule, and I acknowledge that. The federal rule obviously allows for sanctions for oral advocacy after the initial pleading, and Iowa has not extended it. But I do still think that those federal authorities are persuasive to this court. Dismissal is something that federal district courts have the power to do when violations of Rule 11 occur, and I think and would urge this court to find similarly that in the appropriate rare circumstances in which the facts support it, that Rule 1.413 be determined to support dismissal. Thank you.
Mr. Viner.
Good morning, Justices. Justices, opposing counsel, may it please the court. On behalf of Matt Kraus, I am the resistor, although I will acknowledge that I did not file a brief in resistance of the application for further review. In the appeal, we were the movant, the applicant, and the Court of Appeals in reversing the 1.413 sanctions dismissal, I wanted to start by saying that I am reminding myself that this is an appeal that's not about me, and yet the rule is sanction against the attorney. And so what I've tried to do in the appeal and what I've, yes, Your Honor.
Trial court level as well? Thank you.
I was retained following the original action, Justice, and
Modification? That's what I meant.
yes, I did. I did, yep, absolutely. I filed the modification, and one of the elements here under 1.413 is the good faith belief in the litigation that I'm filing. And one of the things as a family law lawyer who's been practicing for 20 years, I do have to take someone at their word to a large extent. Someone comes to my office and says, I want to do this, and I say, why? And so in analyzing a modification, the first thing I do is to say, well, we know that there's a heavy burden in order to change custody in Iowa, that the substantial material change in circumstances is a serious burden. And in order to endeavor on that, I'm always careful to advise clients that if we don't prevail, you're likely to pay attorney's fees. And in this case, the 1.413 motion being filed 9 months into the litigation, we had the hearing in October in Manchester in front of the Honorable Judge Bitter. To your question, Justice McDonald, about evidentiary hearing and having his day in court, I very much don't feel he had his day in court. We had a less than hour evidentiary hearing on the motion. One of the things that struck me as I listened to Ms. Fueger is that Judge Bitter asked me, he said, well, Tom, do you think that you could win a modification trial today? And I said, well, Your Honor, this is a sanctions hearing. I don't need to win today. One of the elements of filing a modification is that relying in good faith on what a party tells me why they want to modify. Yes, Judge, Justice.
I mean, the decree was entered 51 days later, you filed for a modification. And as I understand it, they were still in the Maquoketa School District, right, for that year. And the concern was for the following year, which would have been like 7-8 months away, they didn't want to have to be in the West, or your client didn't want them to be in the West Dubuque School District. And I mean, why couldn't you have waited? I mean, it just seems 51 days seems very sudden, and it doesn't seem like much of anything had changed.
Justice, my answer, while being careful to acknowledge that I can't tell you everything that was told to me because of privilege, but what ultimately led to me filing was my client was advised by his son that he was going to take a gun to school and shoot his classmates. And to me, that is too much of a threat. That necessitates a filing, and that's what I did. And so we filed the modification to say if the children are making those reports.
You filed the modification. Did anybody make a call to law enforcement or the school?
District Court found no. We didn't present evidence on that. I didn't have a trial, Your Honor.
To take it straight to court?
He said in the hearing was that he told his son, we don't do that, that's not appropriate. I believe that Mr. Kraus felt he had addressed it with his son best he could. And then he brought it to me.
Significant change in circumstances. Your own client says he dressed it the best he could. I'm struggling, like Justice Mansfield was alluding to, about you coming in as the second quarterback, somebody else who had done the whole trial. I find that interesting too, that the original lawyer from just 5 weeks earlier didn't file the modification. But 5 weeks, you barely have maybe one child support payment under your client's belt. I'm just wondering, and you say you can't talk about confidentialities, but the petition for modification, what's in there? I'm looking at it. What's in there that's something for a modification should be kind of jaw on the ground, especially 5 weeks later, like she's now living with a sex offender. That's a good one. Or she got in a drunk driving accident and the kids were with her. That's a good one. Tell me what's going to make me go, oh my gosh, that's a good one.
I think a threat of school shooting is a good one.
And I'm sorry, I thought the record is that one of these boys, and these are young kids, one of these boys said he made some statement about bringing a gun to school so he could get kicked out. That was the actual statement, wasn't it?
Sure we ever got to that point.
I mean, I'm just reading from Judge Bitter's opinion. He's a pretty good judge. I think if he put it in the opinion, maybe we can go with that. The other thing is, it doesn't even make sense to me because he's talking about getting kicked out from the district he liked, which was the Maquoketa School District, and the concern was having to move to West Dubuque because because mom wanted to move the school district. So the timing doesn't even make sense. The whole thing doesn't make sense. I'm sorry.
Justice, and I would agree with you that if we'd had a trial, I think I would understand, and we didn't. We didn't have a chance to present evidence. All we had was a chance to present evidence at a sanction hearing about why he had filed this modification. So the West Dubuque question, as I understood it and understand it now, was that they were in Maquoketa schools and their mom wanted to move them into West Dubuque. Whether that was at the end of the year, I believe that was one of the questions, or at semester, I don't recall. And we never got into that because, again, we didn't have a trial. So Justice Christian's, yep.
Order that the plan was to put them in the following school year in the West Dubuque schools. I mean, you had the ability to counter these statements, or if you wanted to, right?
I'm not sure if I feel the same. In that hearing, it was mostly directed, in my recollection, by Judge Bitter asking me whether or not this was enough to go forward. And my response was, well, then this feels like a summary judgment versus a sanction, which I think the Court of Appeals was right. I think that dismissing a family law action and action in equity regarding children sends a bad message. I think it discouraged, sorry, Judge, go ahead.
I take your point, and I think it's a legitimate one. But sort of a legal point I wanted to explore is we decided 2 years ago in guardianship of JW that a district court has inherent authority to dismiss a case for an ethical violation. Now, we can debate whether filing a frivolous lawsuit, I mean, I'm not saying it was an ethical violation here, but it's the same kind of thing. So if a court has inherent authority to dismiss a case for an ethical violation, why don't they have inherent authority after giving an opportunity to be heard to dismiss a case as being frivolous, regardless of 1.413?
I don't think the court should dismiss modification filing. Having that.
He's asking about inherent authority. Don't you think the court has that authority to do so?
I think the district court has immense authority. Yes, I'm going to agree with that, acknowledging that I don't like what happened here. clearly.
Can dismiss it under inherent authority if the opposing counsel says she's going to do it for a rule of civil procedure, but the judge says, I'm not going to do it for that reason, I'm doing it for another. Can a judge do that?
Short answer, yes. I think that if this were a summary judgment, is it within the powers of the court to dismiss I think it's disfavored. I think it's a bad idea. But
A couple other things I've noticed in this file that I think add to and give credence to Judge Bitter's order. I noticed, for example, the income withholding order was signed by a judge and filed on December 28th. And in 15 days, the modification petition was filed. That, to me, as a judge, I would smell a rat with that, too. Somebody all of a sudden has an income withholding order, and they file a modification right away, including child support. So can you, when you put all those facts together, and if I learned those things from looking at the record, doesn't the judge have enough to say, no, this case is going to stop right here?
sanctions rule, I think that you would have to ask what I thought of that. So if I'm frivolous in filing a modification, I would have to be ignoring things that I thought were suspicious, and they would have to outweigh my belief that the threat is enough to proceed. And in this case, I hadn't filed the motion yet. I filed it. Yeah, I did.
You knew there was surely you knew that there was on file a withholding order dated December 28th. Well, I mean, surely you looked at the file before you took it. Okay, it's on file. I'm looking at a file stamp copy. And then also, surely you knew that the allegation of a gun to school had never been turned in. There had been no, I mean, it wouldn't have been nice to attach a police report or something, or DHS investigate. There's nothing other than him telling you that. So those things you knew, correct?
Correct. Yes. And
When it entered its order dismissing. I mean, I just learned it from just looking at the record.
it'd be hard for me to say what the court, I think the court agrees with you. The district court agreed that there wasn't a DHS, HHS finding, there wasn't a police report, some hearsay issues there, Judge. But, you know, I didn't have those. But when I filed it, what I had was my client telling me this has happened. So I didn't have all those things. That's it. Yep, it is.
You wouldn't you, though? By the time you get to the sanctions hearing, the testimony from your client was not great in terms of his motivation or purpose for seeking the modification. I think he concedes repeatedly that there really was no change and he just wanted a do-over.
Are you referring to the text message and the smiley face emoji? Or the...
Things. There's like pages of transcript where he's kind of conceding that there really was no change of circumstances.
One of the things I would need to point out is that I don't have... Go, please.
Isn't it the case, sir, that this modification action is your attempt to do over the things that you don't like about your decree? Answer, yes. And there's pages of that. I mean, so whether or not the sanction's appropriate is one question, but certainly on the facts, the testimony, the evidence isn't great on the purpose for modifying this.
Certainly here at the Supreme Court, looking back on the strength of a modification that was dismissed by the court, I can't disagree. It was never developed. Trial hadn't been set yet, Justice. So I think we were 10 days from the trial setting conference even in the first judicial district, which is different than the sixth, but it usually takes a year or a year and a half to get a trial date from the trial setting conference. So there is a spirit, there is an element of getting in line. So if someone tells me that this is what's happened and we're going to develop that, I relied on the ability to gather evidence and develop this case to see if there is enough for us to proceed to trial. And that's what I relied on.
You do that development of evidence and stuff before you even decide to take a case, don't you? Believe everything your clients tell you. I had thousands of clients. I didn't believe everything they said.
Thousands. And I mean, they sit at my conference table. I mean, everyday Iowans just like me. Not everything, but if someone tells me that their son threatened to take a gun to school, I'm going to act on that. And
just sort of a practical issue. So my family law experience is primarily as a judge, right, rather than from your point of view. And so I'm curious about this. I don't remember very many summary judgment motions, maybe none that I remember. And I understand this idea that it might be disfavored. But in modifications, I'm not sure why it wouldn't be a possibility because you could sort of lay out what the circumstances are and have that sort of a screening and process. And I just sort of want your feedback on that.
Question. In my experience, motions for summary judgments are very, very rare. I've never seen one in a modification or a family law case, with the exception of 2 common law marriage cases. I have seen it in those contexts, but it doesn't come up. Is I guess my short answer. Should it? I don't know. I mean, this certainly prompts me to look at my caseload and think about this. If this is something the court is signaling to us as family law attorneys that we should be considering, do we even need to wait for trial? Because that is largely the practice of, if you file a mod, a good mod or a bad mod, you try to mediate it, you set it for trial, and then up to trial, the risk to the movement is if we don't win, you're going to pay. And so that's how I handle that question.
I mean, the economics of motion practice in a family law case don't really work. I mean, to prepare a summary judgment, you're going to probably have to depose parties, prepare a record, file a motion, file a brief. And at least my experience as a family law judge, most modification and even dissolution actions are a day, half a day to get the whole trial done. They're shorter than it would take to do the summary judgment, typically.
Common for modification. I'm about to go to Polk County District Court and finish a 2-day contempt hearing. So I think the experience varies as far as time. So I think that there is a big difference between the time, but to say that this was a evidentiary hearing on the merits, I certainly didn't feel like it was. I didn't feel like Mr. Kraus had his opportunity to present the evidence in support of his modification. That's why I'd asked the court to affirm the appellate court to the extent of reversing the dismissal. Thank you.
Thank you. A couple of things I want to comment on in counsel's argument. First of all, he started by talking about sanctions against him personally, and I just want to be very clear. The motion for sanction was not directed towards him personally. It was directed to the Mr. Kraus, the represented party, which is specifically allowed for in the rule. And the reason for that was specifically because of all of the substantial evidence determined by the district court that it was Mr. Kraus's scheme and plan to try to undo what was done.
In your motion, as I read it, it's based on Rule 1.413 and not on inherent authority of the court. And as I read the court's ruling, it's based on Rule 1.4113. Is that your understanding too?
It is. I also want to comment on the information provided in counsel's argument about the child allegedly making a statement about taking a gun to school and shooting classmates. The specific shooting classmates is nothing that has ever been said in any of the deposition of Mr. Kraus, in his testimony at the motion for sanctions hearing, and so that is new information about shooting classmates. But I think Judge Bitter correctly found that if you have a child that is saying, I'm going to bring a gun to school, what do you not do? You call the police, you call DHS, you talk to the school. These children were in counseling at the time. You would at a minimum talk to their counselor. None of those things were done, which is why I think the district court.
Timing is, in other words, the modification is filed 51 days into it. They're still, at that point, they're in the McKenzie schools. Those are the schools they want to be in, they like. It's the ones the following year they didn't like. So why would they be talking about bringing why would one of them be talking about bringing a gun to school to get kicked out of the McKenzie schools? That would have had to have happened the following year, before the modification hearing, but long after the modification was filed.
I don't believe that statement was ever truly said. I think Judge Bitter correctly found that Mr. Kraus was not credible on that, and I think the appellate court recognized that in the record and called that whole vague statements a red herring, which I believe it was. Something subsequently offered as a potential explanation for the improper purpose in filing the petition for modification. I'm troubled.
Modification, I didn't see, there was not a supporting affidavit with any kind of details, right? Thank you.
I'm troubled a bit by counsel's argument about the long delays in filing a petition for modification and the quote idea of getting in line. I believe that the idea that we would invite litigants to get a petition for modification on file and then wait for trial and drum up the evidence to support that runs afoul of 1.413. And I think that that, again, is why I urge this court to definitively hold that the district courts do have the inherent authority under Rule 413 to dismiss actions that are filed in violation of the rule because of the long delay. The snapshot in time that is critical for this court is what facts were known at the time of filing. And it is clear that at the time of filing, Mr. Kraus had an improper purpose to try to undo something that he had just agreed to with the benefit of counsel. In the intervening time, in the 51 days between when the decree was entered and when the petition for modification was, we hadn't barely gotten the quadro done yet. We had things that we were still working on, and I don't know exactly, obviously, when Mr. Viner was retained, but during that period of time, I was still working with trial counsel to get the quadro, the income withholding order entered, and within days of this petition for modification being filed, I emailed both Mr. Carr and Mr. Viner because there had not been a withdrawal by Mr. Carr at the time, indicating my concerns that this petition for modification violated Rule 1.413. I attached the text messages and said, I believe this is being filed for an improper purpose, voluntarily dismiss it. And that invitation was ignored, and then we proceeded on to discovery. And I do want to make one last comment. The timeliness argument, first of all, it wasn't 9 or 10 months after this petition. It was 7 months that I filed it. But I asked immediately to take his deposition, and counsel was out of the country. And so the delay there was not on the part of my client. I believed immediately that this was sanctionable, and I needed to gather the discovery evidence that ultimately did support that finding in the district court. Again, I would urge this court to enter an order confirming that district courts have the authority under Rule 1.413 to dismiss frivolously filed actions. Thank you.
Marriage of Kraus is hereby submitted.